discussion of joint physical custody. I'm here to support HF1262 as a first step to the right direction to equity in family court that will protect the rights of children. I'm here on behalf of the Center for Parental Responsibility, known as CPR. I'm the founder of this nonprofit organization which serves over 1,000 Minnesota citizens interested in family law reform, and our numbers are growing every day. Our mission is to remove the obstacles that prevent both parents from being fully and equally involved in the lives of their children. Who could ever imagine that our mission to ensure that children have equal access to both of their fit-loving parents would be so controversial? It makes no sense. Ensuring children have equal access to both fit-loving parents who want to fully participate in the lives of their children should be a no-brainer. But our laws and our courts, and clearly by the looks of our opposition, attorneys and other government officials, are preventing a child's right to equal access to a fit, loving father who has done nothing wrong in the eyes of the law except agree to the involuntary divorce on demand that is initiated by the women nearly 80% of the time. Currently in our system, drug-addicted prostitute mothers who have been convicted of neglect of their children have a government child protection agency ready, willing, and able to help them turn their life around and make them a better parent to regain custody. But in family court, with the current law, a dad gets instantaneously stripped of custody with the stroke of a judge's pen because the custody evaluator said the wallpaper in his kid's room hadn't been updated or the parents can't cooperate. Almost everyone knows that game. The phrase, parents can't cooperate, is code for mom wants sole custody and saying they can't cooperate will give her a slam dunk order in her favor. In these cases, the kids are used as weapons against the father. Without a statutory presumption of joint physical custody, we continue to destroy our society one child at a time by our current family law policy, which systematically removes fathers from the lives of their children like widgets on a factory line with no human care or concern for the short-term impact or long-term outcome on these children. Why is this done? Because that's the way it's always been done? Because that's the way our society did things 35 years ago? Because that's the way lawyers want it? 35 years ago, we began no-fault divorce. However, 35 years later, we still continue a fault-based custody model to support a divorce industry that forces the system to determine who is the better parent, so the family court can divide the children like a stick of furniture that can only reside in one place. The so-called best interest criteria is so subjective that the decisions can swing any way that's needed to fulfill the personal bias of the custody evaluator or the intentions of the judge or maintain the status quo. Depending on the research, 85 to 95% of the cases, mothers get sole physical custody and dads are stripped of custody and limited to seeing their kids every other weekend, only 4 days a month. Someone told me once, the best way to determine whether there's discrimination is to reverse the roles. And if it feels uncomfortable, it's probably discrimination. So I ask you, if the roles were reversed and we gave dads sole physical custody 85 to 95% of the time and limited mom to every other weekend, would that seem like we have a problem? Current laws are not just segregating fathers to the back of the bus, we're booting them off the family bus. And for the sake of our children, this must stop. You probably place the burden on the judges to do the right thing, but you know what? I've heard judges blame you, blame the legislature, and say the law makes us do this. The current model promotes conflict. The current model is not working, so the Minnesota citizens ask you to ensure a statute that is abundantly clear, and the only sound constitutional decision is equal shared parenting, unless there are findings of abuse, harm, neglect, or abandonment according to a legally sound evidentiary standard. If you're truly worried about domestic violence, stripping a child of a fit, loving father for no reason is the worst form of child abuse there is. But currently, that abuse is sanctioned by statute. And we can't overlook the well-known fact that the extent to which false allegations of abuse are used by women routinely to gain an advantage in custody. The domestic violence industry may be trying to persuade you here and behind closed doors that joint physical custody will increase abuse. All the research says the opposite is true. The domestic violence Paid advocates neglect to tell you the true fact that perpetrators of abuse are equally as much women as men also. Joint physical custody will reduce domestic violence because it distributes the power equally between two fit, loving parents, because the primary cause of domestic violence is a feeling of powerlessness. I ask you, does the Equal Protection Clause of the 14th Amendment of the Constitution apply to the fit mom and the fit dad, or just the fit mom? Our legal counsel finds that in the absence of an actual finding of unfitness, a court order based on the non-custodial custodial model that we currently use operates in violation of the constitutional right of each parent. As citizens, we expect our legislator to protect citizens against the government and enact laws that effectuate the Constitution. All of the opposing the bill here today are getting paid to be here. It's their job. All of us here supporting the bill today, and we had 14 of us that aren't going to get to talk, all of us are unpaid and have had to take vacation time to be here. We have no paid lobbyists, but we're here because we want to fight for children for generations to come. The citizens are asking you, the legislature, to protect the fundamental rights of parents and children and pass a presumption of joint physical custody. And I have a hand up for you.
Thank you. I'll give you a couple.
Thank you, Mr. Chair. Mr. Chair, I have an attorney, Joe Field.
Do you want to have your other witnesses come down? Are you ready?